Hi, I'm Nicole Hemrick, and I'm the managing partner at Hemrick O'Malley, PLLC. Today, we're talking about fiancé visas. Many of you have heard about the show 90 Day Fiancé, and why is it called that? Because after entering the United States on a K-1 visa, you're supposed to marry the petitioning U.S. citizen within 90 days of your entry or admission to the United States. And then what happens? Once you marry, then you can file your adjustment of status application. That is your green card application. Now, what if you didn't marry within the 90 days? I have heard of this happening. I had a few people that this happened to for, a variety of reasons. Somebody got sick, or during COVID, certain locations were closed, or were giving limited appointments for marriage ceremonies. But whatever the reason may be, let's say hypothetically you and your fiance do get married, but it's after the 90 days. What do you have to do? Well, then you just do a normal marriage-based adjustment. So you'll have lost some time and money because of going through the fiancé visa route, but your spouse can still file an I-130 petition for you as the spouse. You could still go ahead and file your I-485 application to become a green card holder and your work permit and your travel permit. There might be some other scenarios where you and the petitioner never get married. So then what happens? One possibility that I've seen might be that you came here and the relationship was abusive. Well, if that's the case, you might have options to apply for a U visa or maybe even a T visa. So that's one thing that you can discuss with an attorney. Another possibility might be, and I've seen this happen as well, maybe down the road, you do find that person that you want to spend your life with. Then what do? Okay, you can't adjust status based on a petition from a new spouse, but that new spouse can sponsor you, and then you can consular process, which means you can get your visa abroad. So you'd go through the provisional waiver route. Your spouse files the I-130, you get that approved. When the case is transferred to the National Visa Center for immigrant visa processing, then you file the I-601A provisional waiver application. Once that's approved, you complete the immigrant visa process, and ultimately you go for an interview at your embassy or consulate abroad and pick up your visa there and then come back. And typically people on provisional waivers come back within about a month of the time that they left. If you have questions about this or any other immigration question, we'd be happy to speak with you. Our number is 833-848-7838.